because our charter, the Moose Lodge Charter, says no blinds. Okay. Leroy is upset. This is 1971. So he sues the Moose Lodge for discrimination. Now, here's the legal question. Is the Moose Lodge subject to the concept of state action? It is a private club. All right? Leroy Irvis argues that because that private club has a liquor license from the Commonwealth of Pennsylvania, right, without which it cannot serve liquor, and is therefore subject to the routine control of the Liquor Control Board, right, as to who it can serve and all the rest of it, because of this ongoing contact with the Commonwealth of Pennsylvania through the Liquor Control Board, that constitutes state action. The Commonwealth is invested in the operations of the club. How would you rule? Well, how many would decide for Leroy Irvis? Is this a form of state action? A few people. All right, okay. It's a hard question, and the court divided on the question, but the court ruled in favor of the club and against Mr. Irvis. Okay. It's a close case, but I give this to you as an example. This is the kind of thing that the court entertains from time to time.
Excuse me, what court made that decision?
The Supreme Court of the United States. Yep.
Oh, the Supreme Court.
Oh, yeah, yeah.
Went up
What was
there.
the
The case is called, it's 1972, the case is called Moose Lodge number 107 versus Irvis. Interesting case. Okay, so the larger point is state action is yet another creation of the Supreme Court that enables it to expand the coverage of the Bill of Rights into certain segments of the private sector. Now, if you're Augusta National Golf Club and you exclude women as members, I'm not making this up, that's okay. Because Augusta National Golf Club doesn't do any of these three things that are listed on your hand. They can be just as nasty as they want. Yeah.
But Rotary was told it couldn't confine itself to men members, they had to get women.
Who
What's
did?
the difference? The Supreme Court told Rotary that it
Oh,
has
yes,
to
that's
be-
right. That's
What
right.
is the, what's the
Yeah.
subtle difference there?
Yeah, yeah. Well, that's a whole other thing. Now we're talking about freedom of association, right? First Amendment, freedom of assembly, freedom. Yeah, and that really cuts both ways, doesn't it? Because the issue in that case was the right to be included. The women wanted in, Rotary said no. Right? But then there's a counter right, the right to exclude Augusta National. Right? We don't want women. We want to, drink with the old boys after the round of golf, and that's it. Yeah, that's an interesting case. And what Brennan said in the Rotary case, and earlier in the Jaycees case, you all know who the Jaycees are, right? The Jaycees had exactly the same problem. Their national charter excluded women, right? And a couple of the Jaycees clubs out in the Midwest, I think Minnesota, Michigan, said, we're not going to abide by the national charter. We are going to admit women not just as auxiliary members, but as full voting members. And their charters were lifted. Right? They were penalized, in other words, by the national. And so they brought suit against the national. And they won. And Brennan wrote that, and this gets us a little off point, but it's a fascinating area, because what Brennan did was to sort of parse the situation, and he said, you know what? speaking about private organizations, private associations, there are associations and then there are associations. And he said, they have different characteristics. Imagine a kind of continuum, a line of organizations, okay? He says at one end, you have organizations which may be very small, they may be very intimate, they may have a dedicated mission, like a church, for example, even a family unit. They may be extremely demanding in what is required for membership. But then as you move across that line, that continuum, you get to the other end. And there you have perhaps very large, amorphous organizations whose mission is as big as all outdoors. You know, basically we want to do good. Okay? Or in the case of JCs, we want to teach our young people how to be better business people. Right? That has nothing to do with gender. All right? It has to do with business practices. Okay? And when you get over there, says Brennan, if you're that type of a club, you can't discriminate on the basis of sex. Because it does nothing. If you allow women, it does nothing to diminish or change your mission. Your mission remains exactly the same, and indeed it's probably enhanced with the admission of women, right? As more and more women become business people, networking, so on and so forth. Okay? So it depends, said Brennan, on the type of organization. And you look at different elements of the organization, like size, intimacy, mission, and so on. Okay. Let's talk about something else. One more thing. The other handout. Now let's talk about the power, expanding the power of the Bill of Rights itself. Let me take you back historically to the 1890s. In the 1890s, the Supreme Court developed something called the reasonableness test. When you lay a piece of legislation, whether it's a local ordinance or a state law or an act of Congress, doesn't matter, but when you lay that against the Bill of Rights, the text of the Constitution, you have to make a judgment. Do they square? Do they comport with one another? If they don't, if there's no way to reconcile the differences between the legislation and the Constitution, you have to throw out the legislation. Okay. Well, in order to do that, you need some kind of a test. You need to ask some questions to get at the answer. Okay. So the court fashions a simple test. They call it a test. It's actually 3 questions. And the questions are these. First of all, is the challenged legislation reasonable? Reasonable. Okay. Or is it arbitrary and capricious? Is it aimed at damaging a particular group or something like that? Is it reasonable? Okay. Second question, are the means to carry out the legislation reasonable? And finally, third question, is there a close relationship, a reasonable relationship between the end sought by the legislation and the means chosen to carry it out or to achieve it? If the answer to all 3 of those questions is yes, they're all reasonable, then the challenged legislation is constitutional. Now, let me give you a simple working example so we get clear on this. Let's take Gettysburg. Suppose Gettysburg, the Borough Council passes an ordinance that says from now on we cannot permit any gathering of numbers of people in or around the square for any purpose. Right? Protesting, picketing, rallying, doesn't matter what the purpose is. We can't allow it. Why? Because, you know, we're a tiny little town of 8,000 souls. And yet we are entertaining 2 million people a year. And we just can't afford to have situations where vehicular traffic or pedestrian traffic is seriously hindered in and around the square. People have got to be able to move about, all right? So if you want to hold your rally, or you want to protest something, or whatever, fine, go to the rec park. Do it there. You can't do it in the square, okay? So now let's suppose, this is hypothetical, let's suppose we have a pro-life group, okay? And it's January 22nd. We all know the significance of that date. And so we're going to have a little group gathering on the square, all right? We're going to stand out in front of the pub, and we have some signs here, you know, pro-life and all that, and honk if you believe in life or whatever. And there are 20 or 30 people. And the officer comes up to them and says, "Who's the leader of this group?" So, steps forward. All right. Well, he says, "You're all under arrest." He says, "Here's the ordinance, and you're all going to be fined X number of dollars because you have violated this." Okay. So your attorney shows up in court and says to Mike George or whoever, "May it please the court,